So, welcome to Criminal Litigation Drafting, Part 3. We are going to continue from where we stopped, according to the course outline that is there on your screen. We are going to start with the charges, then we are going to start with preparation of files, then we go to charges, then we go to bail and board topic. And I hope we are going to finish today. Drafting, as I said, these are skills that someone acquires over time through drafting practice. They usually say practice makes perfect. And I believe it is not fair to start the next drafting, the next topic until you get a student gets the previous drafting how it's done. So generally drafting tests, it usually tests your knowledge on the area of law, but now put in a format, maybe a pleading or something. So generally that is the purpose of drafting, the structure and the content. And of course the timing. Some of these drafting, good draftings, I'm going to, because we're also dealing with year 2008 to 2019, some of these drafting, I'm going to upload them in the website under notes area, the drafting which have been done well. And of course, I said that the topic, the drafting that has not been tested in the various topics, I'm going to test on mock exams drafting. So we can start. The first question was question 2B on preparation of subfile G. It was July 2014. Question 2B, July 2014, which I'm projecting. And I'm going to read the question. The question is on the screen. Ms. Carasso Patapotea is known as described as party activist and a member number 1 of Upendo party, political party. Her business card describes her as a founder member and party leader of Upendo party. Her business card describes her as a founder member and a party member of Upendo party. On 4th March 2013, Ms. Pata Potea ran for Kasarani Ward's member of county seat. She lost to Honorable Post Njari. Honorable Njari ran on the ticket of Mababi Party. Since her victory, excuse me, Honorable Njari has been cooperating with the party in power. It's believed that the county commander of police is her Mayaku County tends to listen to her quite favorable with hopes that she would secure him a promotion within the police service. Ms. Jari close relationship with police county commander appears to have made her believe that she's beyond reach of law. At social gatherings and political, she calls herself Serikali, which terms understood is a street balance to mean government. On 28th June 2013, Ms. Jari, on an inspection tour of development project in Lahore, ran into Ms. Pata Potea along Nema Road. Ms. Pata Potea demanded dialogue with the ward by all stakeholders to agree on prioritization of development project. An argument erupted, after which Ms. Jari slapped Ms. Patapotea, causing Rata to bleed profusely. Ms. Patapotea was rushed to the nearby Mayaku Teaching Referral Hospital for treatment. Her situation was described by the duty doctor, Dr. Esther Roy, as unstable. She was moved to the intensive care unit on said hospital. She slid into a coma. She had been in a coma since then. However, on 14th July, on her condition deteriorated drastically, leading to her death. A post-mortem report then revealed that the deceased death was occasioned by internal bleeding in the brain and resulted from a blunt object. The blunt object was described as a slap or such object. While Ms. Potea was in coma, Modawe kept herself busy on political train meeting voters. The county council did not take steps to bring Orabojadi on account of the slap. Several pleas to him to cause Ms. Jari to record a statement and prepare a comprehensive investigation file has yielded no fruit. You are Mayaku County Head of Director of Public Prosecution. This matter has caught your attention of the Director of Public Prosecution. The DP has called you and instructed you to personally take charge of preparation of the prosecution file. The elder son of the late Ms. Patapotea, Ms. Vidil Mandevevu, calls on you. On hearing the news about the DPP intervention on the matter, it requires a write-up to you. What is the ideal file for the discourse offense would contain to amount to a successful prosecution? Prepare with specific details. What you must have for each sub-file. So, what you must have for each sub-file, it's a theory question which needs you to have crammed the sub-file A to H. So which are these sub-files?
So sub-file A is the initial complaint by the complainant. And then sub-file B is the sketch map and documentary exhibits. Then sub-file C is, is it the witness statements? I believe. No, sorry, expert reports. It's the expert reports like ballistics, P3 and the rest. And then sub-file D should be, sub-file D is, I think, the police reports. Then sub-file E, is the, sorry, where was I? Sub-file C is the expert reports. Then sub-file D is the prosecution witness reports. Then sub-file E is the cautionary statement and the statements made by the accused on inquiry. F is the investigative diary. Then sub-file G is your list of witnesses, those lists. Then sub-file G, okay, I'm confused. G is your charge sheets. H is your list of exhibits and exhibits, documentary, whatever, evidence, all that. Yes. Then sub-file I is the covering report. Then sub-file J is the correspondence sheet. Yes.
So, for purposes of exam, you need to have these sub-files in your fingertips to cram them. Then, as we said in the last class, that you can be told to, last class but one, you can be told to draft, and question B is of course told you to prepare sub-file G, And we said you must be very creative when you are doing these sub-files. So, of course, from the story there, we know that Patapotea, the lady was murdered. He was knocked by this person. Njari slapped her, and then he went to a hospital to a coma, then died. So sub-file G contains the charge sheet. So that is what we are supposed to have drafted. And if you remember in our last class, we said a charge sheet for murder is called an information. And of course, you did not have any problem drafting an information. Say for one thing I want to correct. You see manslaughter. Manslaughter is someone is charged with manslaughter at the magistrate court. So when you're doing an information, you only charge, you only put one count, and that is count of murder. You can't put count of murder, then alternative charge to be manslaughter, because murder and manslaughter are not taken to the same court. Are we together?
Yes, we are, Mwalimu.
Yeah, so if you are told to draft, when I told you, when someone has died of, even if there was no criminal intent, you charge someone with murder directly. It is for court now to decide if the person is guilty of murder or manslaughter. Sawa.
I remember you had asked me my reasoning why you cannot charge someone else. I did that homework. And it's based on the general rule in framing capital offenses is that no other count or of another offense should be joined to a count which carries a death penalty in the event of conviction. That case is Valezi Kashiza versus Republic 1954.
So that
yes.
means you can only be charged with the robbery in various alone.
Yes, in practice. Of course, like practically in an exam, that's not what will happen. But like I think that's what they assume in practice. But then they say there's an exception to the rule in the framing of capital charges. If another count may be joined to a count which carries a death penalty, where the additional count is based on precisely the same facts as the serious charge.
So yes. you can be charged with robbery, then attempted robbery.
I guess. I think that is what it says.
Okay.
Yes.
Can you send me that case?
No problem. I'll send it.
To my WhatsApp.
Okay.
That is very, very important. So so every time you are charging someone with information, you can't charge someone with manslaughter also, because manslaughter is taken to the magistrate court and murder is taken to the high court. So if someone is to be charged with, if of course if the facts tells you charge someone with manslaughter, you charge him with manslaughter. But the general rule, even the DPP, even if there was no criminal content, They charge someone with murder. That is a practice. And that's how we should do in an exam if we are not told to charge someone with manslaughter. Of course, the court will look at they see that there were no criminal intent, and they are going to convict the person with manslaughter. Are we together?
Yes, we're together, Mwalimu.
So that is the only thing is there. You correct. So we go to the next question. The next question is on. We go to charges, draft framing of charge sheet. That is topic 6. And I gave you a question here. This question was question 1, July 2013, and which carried 15 marks, which I want to read. Then I'm going to look at your answer. We are going to look at the answer together. Ms. Johnson to Musisi, a national of the Republic of Somalia, visited Kenya on what he described as spring vacation. He landed at Jomo Kenyatta International Airport in Nairobi on 12 March 2013. He landed at Jomo Kenyatta in Nairobi on 12 March 2013. Ms. Tumisi booked himself in the presidential suite of a hotel called Ole Sarani in Nisili. At about 2030, Ms. Tumisi walked to a bar and a Brockway for purposes of entertaining himself. He entered to Pedan bar and disco, and then ordered for a bottle of Tusker beer. Miss Pansy, the waitress, who considers herself beautiful, as is all times addressed as Miss Isri, was to hand to serve Miss Tumisi. After taking several drinks, Miss Tumisi got attracted to Miss Pansy and invited her to a drink. Since Miss went a venue, as soon as Are you Marianne?
Yes, Mwalimu, I'm good.
Oh, it's logged out itself, eh? I don't know what the problem is, eh? But I'm going to continue anyway. Hope you can see my screen, eh?
Yes, I can.
After several drinks, Miss Tumisi got attracted to Miss Penzi and invited her to drink. Since Miss Penzi was on duty, she declined to join me to Miss but suggested that she could join him in a different venue as soon as her shift ends at 12. The duo agreed to meet at Nyerere bar within. At 12:15, Miss Tumisi has already pitched tent at Nyerere bar waiting for Miss Penzi. Miss Penzi considered sharing of a drink with Miss Tumisi a major event, of which they dashed home to dress up for the occasion. She entered into Nyerere bar and restaurant at around 12:30 and joined Miss Tumisi at the table. After being together at the table for about 45 minutes, Ms. Tumisi, a huge stocky man known as Buddha, walked in and went straight to Ms. Tumisi's table. While shouting at Ms. Tumisime, he grabbed Mr. Tumisime by collar and smashed his face on the wall. So the criminal charges have started. The charges here. A fight ensued between the two men. While attempting to scare away Miss Buddha, Miss Penzi threw at his face. A fight ensued between the two men. Another charge. While attempting to scare away Mr. Buddha, Miss Penzi threw him a bottle of Tusker beer. Another offense. The bottle smashed at a Sony TV set at valued at property of Nyerere Bar and Restaurant. That is another offense. Police arrived at the scene at 1 a.m. Attracted by commotion, they arrested Mr. Tumisi, Miss Penzi, and Miss Buddha. On taking the three to Kamukoji police station, it was discovered that Mr. Buddha is believed to have assaulted Mr. Maji Sukari on 20th February 2013 for allegedly another offense at stealing 2 kilograms of sugar from Mr. Buddha's house in Karen View Estate. Mr. Buddha has since been on a run. While at the police station, it also discovered that Ms. Tumisi was in possession of a firearm with 1 round of ammunition without a license. A draft an appropriate charges. So this question is testing you on your how you competently you can be able to draft charges. And we talked about last time on joinder of persons, that people who do the same, who are guilty or accused of the same action or offenses can be joined together. Then the same counts can be joined. Different counts or the different offenses can be joined together in one charge sheet, provided they happen in course of the same event. So that is the trick of this question. Let me look. Now we are going to open your answer. You can see your answer.
Yes, I can. And I'm already seeing mistakes.
So a question of 15 marks, we said you should take around 38 minutes. So of course, this was 11:39 to 12:02. That was within time. If a question has not given you the if a question has not given you, if the people to be charged do not have 2 names, is for you to give them names. Jonathan Tumisi, Buddha Boss, and then Penzi Mrembo. That's okay. ID, passport, sex, nationality, age, address. I think for the heading that is okay. So count one charge, threatening breach of peace contrary to section 195 of the Penal Code. So you go sequentially according to the question. You see, the first offense is here. While shouting at Mr. Tumisi, he grabbed Mr. Tumisi by the collar and smashed his face into the wall. So that should be your first charge, which is assault.
I was okay. My issue with this question, and I almost asked you yesterday before I drafted it. Okay, I was going to charge it as count 2, but then I forgot and went to other things. But my issue is when we're charging a large group of people, do we start with the common charge they all face, and then we do additional counts for the individuals, or can you start with an individual charge for one person? Because that's why I started with the threatening of peace, because they were in a brawl, all of them. All 3 of them were in the brawl.
The correct thing is what you are saying. You start with where there is joinder of persons. Before now you go to individual persons. So that's okay. That's okay. I had not seen that point. So Jonathan Tumisi Budabos and Pezi Berevo on 12 March 2013 at Nyerere Bar and restaurant within Nairobi County. You brewed in a to me you. This word is what?
Oh, brawls.
Yes, you browed. Browed in a manner that caused breach of peace. What is the meaning of browed? Brilled.
Fighting in a manner.
Oh, it is called build.
Yes.
Okay. Jonathan Budabos and Pezi on 12 the Nyerere Bar within Nairobi, and you build in a manner that caused breach of peace. Okay, that is okay. That's correct. And you quote of course, you have the penal code county 2. Then you must ask yourself, count 2, possession of a firearm contrary to section 4 of the Firearm Act, particulars of the offense. Jonathan Tumisi was the one who was caught without possession with a round of ammunition.
Now, there in count 2 is where I made the mistake. I think I should have done the assault by Budabos first, but then I forgot, and then I remembered it after I'd already done this other 2, and I couldn't cancel. Yes, so I think the assault should have been count 2, and then count 3 should have been this one for Penzi, the destruction of property.
Yes.
And then now when we go to the police station, the 4th count would have been the way he was found with a gun on him during checking by police. And then the one I wasn't sure about also, but I didn't do it in the end, is whether we should charge Budabos with an additional count of the assault earlier, because he doesn't form this chain of it's not in the same transaction.
Yeah,
you know.
So that is the trick of the question. What you ought to have done is to draw another charge sheet.
Yes.
That is where was the trick of this question, because they cannot be, they don't form the same transaction. So you
Yes,
ought
yes.
to have drawn another charge sheet now, because you see these people, all these people, Penzi and Penzi, Murembo and Buddha are going to be charged in the same criminal case, and the state will bring all these charges. But you see, the other offense occurred some time back. So Buddha boss, you are also going to be charged in another criminal offense where he assaulted this person. Are you getting?
Yes, yes, I'm seeing it now.
Yeah, so you ought to have charged. That is now the trick of this question.
Yes.
Yeah, so this means if you used here some, you see, you say here you used 23 minutes. You see now where your other 15 minutes ought to have gone.
Yes, I'm seeing it now.
Yes. So let's continue with this charge. So possession of a firearm, Penzi, common assault, Budabus. Yes, after, because Jonathan Tumisi is alone, Penzi Rembo is alone, then Budabus. All these people, it is alone, but here you charge them jointly. Nini count one, sindio?
Yes, count one, it was all three of them.
Yes, so the other one, if it is they are alone, so it can take the form of any person can start.
Yes.
So there is no mistake there. So count two, possession of a firearm contrary to section 4 of the Firearm Act. You see, in an exam scenario, and in an exam scenario, you see there are charges which are not found in the penal code. And penal code, penal code, you are supposed to go with it in the exams room. So it is for you to go to know some of these offense that someone can be charged with, and you need to cram them before an exam. And of course, section 4 of the Firearm Act is one of them. Then they usually ask about rape. So it's for you to, so where someone has been raped, you need to know section 3 of the Sexual Offences Act 2006, which applies when an adult was raped. If it is attempted rape for an adult, section 4 of Sexual Offences Act. If it is defilement, is section 8. Attempted defilement, section 9. Gang rape, section 10. They ask even, I'm reading page 164 of the year 2008 to 2019 Q&A. Hijacking and destroy ships, contrary to section 370. All the other offenses are in the penal code. Operating an employment agency illegally, section 56, 59, and 61 of the Labor Institution Act. Being in possession of narcotic drugs like bangi, section 3.1 as read section 2A of narcotic drugs and psychotropic substance control act. So it's good for you to in part 2 of the charge sheet, all those questions that I've asked the charge sheet, go and look at some of the offenses there which someone can be charged, which are not found in the penal code, and make look at where they are found in the various laws, and then make a table and that you not be to not count you unawares in an exam, because you see a charge sheet is very particular. If you don't know the the charge, the count, you can't do the charge sheet. You know that?
Yes, Mwalimu.
Yeah, it's very direct. If it is possession of firearm contrary to section 4, it is possession of firearm contrary to section 4. You can't say section 5. You fail. And charge sheet is a very question that can come. So particulars of the offense: Jonathan Tumisi, on 12 March 2030 at Kamukunji in Nairobi country, you are found in possession of a firearm without a license. That's okay. Malicious destruction property, contrary to section 339(1). P.S. Mirembo, on 12 March at nearby an restaurant within Nairobi County at Rwanda, you caused unlawful damage to Sonnet valued at 5,000. Property of Nyere, that's okay. Common assault contrary to section 50 of Penal Code. Budabos, on 12 March, this is not common assault.
It's assault causing bodily harm.
Yes, because common assault is the one you don't, when you slap someone.
Oh, okay.
But here it is 251.
Okay.
251. Budabos on 12th January of Nyere Bara restaurant within Nairobi County, you assaulted Jonathan Tumisi by slapping his, where then you continue saying this one caused grievous harm. And then there is section 251. So you must know that difference. When someone, for example, says he was slapped, that will not cause bodily harm. But if someone it was done, then you quote 251. Then the second charge sheet we said you Buddha for assaulting Mr. Maji Sukari with assault causing bodily harm. Are we together?
Yes, we are.
So we go to the next question. I think now we are done with charge sheet. Do the things I've told you. We are not going to do another charge sheet. So we go to the next question, which was on quashing criminal charges. Let me open the question. Drafting quashing of criminal charges is a very common question, or you are told to quash the proceedings of the lower court. It's also another thing. It's a very common question. So the question is on your screen. I'm going to read it. Keywords. Always when you're reading a question, look at the keywords. In fact, when you're reading question, you can go straight to what they're asking here. Draft an appropriate to pleading to quash microcriminal charges pending before the lower court. So, you know what are the keywords you are going to look. So, Michael Kamau was employed by Britam Insurance Company as insurance claim investigator. In 2005, he was assigned a duty of investigating a claim of compensation by insured client for compensation of a car after an accident. In the course of investigation, the petitioner interviewed the insured, and more than was supposed to be he, 7 other persons. Upon completion of investigation, Mark Kamau found an opinion that the claim was genuine and made a finding that the insurance company was to compensate the insured 7 million. Michael Kamau left Britam in 2019. Early this year, Kamau was arrested by CID officers and was informed he was to be charged with criminal offense following complaint from Britam. Upon further inquiry, he was informed by officers that Britam conducted an audit and investigation and was found that during his employment, that then Michael Kamau colluded with the insured to write a favorable report to them so that they could get compensation. In September 2023, Michael Kamau was charged in the Magistrate Court, Nairobi, with forgery and theft by a servant. The charge sheet did not disclose particular of the offense, and despite several requests by him to be supplied with the particulars of the charge and the document, the prosecution refused, and he was forced to take plea. Michael has now hired you as his advocate. After going through the interview and perusing court file, you are satisfied with how he was treated by the police, prosecution, and the magistrate. You are not satisfied with how he was treated by the police, prosecution, and the magistrate. Draft an appropriate pleading to quash Michael Kamau criminal charges before the lower court. So, of course, one of the violations here is that Britam ought to have given him a hearing before they made a conclusion on him, on the audit. Of course, the police did not summon him to record a statement before when they were investigating him. They called normally to charge him. Then he was charged. The charge sheet did not disclose the particulars of the offense, despite several requests to be documents. The prosecution was he was not given. So these things bring to light the articles like fair administrative action, right of an arrested person's fair trial. So these are some of the things you are supposed to do. And in a question that you have been told to quash a charge sheet of proceedings pending before the lower court, I told you in a sometimes when we are dealing with the criminal past papers that you can either do a judicial review application or you can do a petition. Of course, you can, if the question can direct you on how they want you to draft. When they talk about infringement of rights, petition, blah blah, it can lead you. It's leading you to draft a petition. But if they tell you that it is it's open like this one, you can do the two applications. Of course, if the time has relapsed between the time he was taken in court, there is a lot of time that has judicial review application. For you to go to seek for leave, it must be within 6 months of the action. So if time has gone so much, it's better to draft a petition. Of course, in the other question, they'll tell you the leave has already been granted. So that it tells you that you don't need to go through the leave stage. The leave has already been granted. So the question is just telling you to draft the application, which is notice a motion and supporting affidavit. Are we together?
Mwalimu, I had a question in this one. So I don't know if it's the one I attempted both. I'll check and let me check in my book which one I did. But this question, there's a matter I actually handled when I was employed. And it had the issue of where a report comes out and you've been found to have done like maybe corruption or stolen from the company, and you were dismissed, and then now it's like in now payment of your terminal benefits, the company wants to subtract their own losses as a result of your action, and they didn't give you a hearing. In this one, he was already gone by the time they were doing the investigation. So can we still really apply the provisions of the Administration and Employment Act in this question?
Fair administrative action. You know, this question is not about this is not employment. This is the year is not about employment. This year is fair administrative action. And if you look at fair administrative action, it beats both state and non-state organs. So, and it was enacted pursuant to Article 47. When every person is you know, the issue here is every person has a right to administrative action, every person. So it beats both the it have a right to administrative that is expedient, efficient, lawful, reasonable, and procedural failure. If a right to a fundamental freedom of person is likely to be adversely affected by administrative action, the person has a right to be given written reason for the action. Of course, you go to the Fair Administrative Action Act, which requires that you are supposed to even summon someone, give them a hearing. Are we together? So here it is not about there is nothing in employment here on that is in dispute. Are we together?
Yes, I was just asking because I'm okay. Please come again on what you've said with draft, because I'm looking at my work and I also did it as a JR.
Yes, that's the work I want.
I did. Yes.
I want to open it. We see.
Yes.
We want to open it. We see.
Because I tried it also as a petition, you'll see. But like my grounds for my petition were not very strong. That's why I was asking if we could bring in the element of employment so that we see if we can bring that his employment rights were also infringed upon.
But you see, those are facts you are told you are adding on the question. You see, the question here is not, he left Britain, and we are not, you don't add facts in your question. We are not told that how he left Britain was bad. Maybe he got another greener pastures. But the problem with Britain is doing an audit and making finding without informing him. So that is fair administrative action, right to fair administrative action, which it is in the contention. And of course, you can do it as a petition. You bring the right of fair administrative action, you bring the right of an arrested person, you bring right to a fair trial. Article 47, 49, and 50. There are so many things here there you can say.
Yes, my thank you.
So let's see. Let's see. Question 5. So, the question is there.
Mwalimu, I've been meaning to ask.
Yes.
When you do a petition, does it stand alone? Does it need an affidavit?
Petition is an affidavit. Is petition.
So you do. Mm-hmm.
You do a petition and an affidavit. You are going to look at it.
Okay.
Yes, we are going to look at it. We are going to look at both ways right now. But let's start with JR. So, a question of 20 marks. You are supposed to draft a chamber summons for leave. Then you do a statutory statement, and then you do a verifying affidavit. Those are things are enough for a question of 20 marks. If it is a question of 15 marks, you can do chamber summon and of course you can do chamber summon, statutory statement, and verifying affidavit. If it is a question of 5 marks, you do only a chamber summon. So it depends. But when you are doing, you don't need to do you don't need to do a notice of motion. It's not practical. And why should you do a notice of motion and not do the affidavit? So you either do a JR of 20 marks, you either do, of course, with also of 15 marks, you do chamber summon, statutory statement, and verifying affidavit, or you do a petition and is supporting affidavit. Notice of motion, leave it. But if they have told you leave has already been granted, you do now the notice of motion and supporting affidavit. And that's why you say, dear, this question you use 58 marks, 58 minutes. Of course, it's because you drafted a notice of motion, which was not really necessary. The 3 documents above are enough to give you 20 marks. Are we together? That far?
Yes, Mwalimu, we are together.
So, Republic of Kenya, in the High Court of Kenya at Nairobi, miscellaneous application number 20 in a matter of package for leave to apply for judicial review orders. If you are doing JR, do you read it, use petitioner and respondent?
Applicant and respondent.
Yes, you use the applicant is the Republic. Then the respondent is the Director of Public Prosecution and the Chief Magistrate's Court. Then the expert applicant is Michael Kamau. Are we together?
Yes.
Yes, you don't use petitioner and respondent. The public is the applicant, then the respondent, as you have said, then the expert applicant for JR. For petition and supporting affidavit, for petition, you can put it as it here. Now, chamber summons. When you are when you are in a criminal, when you are drafting a chamber summon to quash, charges in criminal procedure, in criminal, you don't quote under Order 53 civil procedure rules. This is purely for JR, which are you know, this question can also come in the civil proceedings. So you quote 53 civil procedure rule in the civil, JR in the civil litigation. Are we together?
Sorry, come again. What should I have quoted?
You quote only section 8 and 9 of law reform. In JR, for civil litigation is where you quote Order 53 of civil procedure rules. Now, because civil procedure rules apply only for civil litigations. Are you together?
Yes, we're together now.
Yes. So you ought to have quoted section 8 and 9 of Law Reform Act and Ambury registration. Let all parties attend the Honorable Judge on the Chambers on the dash of 2023 at 9 on the forenoon thereafter, as the Council of the Account may behead the applicant for the orders that leave to issue to the applicant to apply for an order of certiorari to quash the charge sheet in the Chief Magistrate Court at Nairobi. Another very, very important order you are going to be seeking is the certiorari orders given do apply a stay, stay the proceedings pending before the Chief Magistrate Court. Are we together?
Yes, we are together.
Because you see, the reason why I'm saying you don't need to draft a notice of motion, because a chamber summons, if it is given, you pray for the certiorari to quash, then the second prayer is to stay the proceeding in the Chief Magistrate Court. So when leave is granted for you to now serve, for you now to now bring the application notice of motion, it is also the court will usually also say that by granting of the chamber summons application, they stay the proceedings at the lower court. So that is a very, very important prayer you should add when you are doing the chamber summons. Eh? Are we together? To that
yes,
point,
Mwalimu.
we are together.
Yes.
So, if you look at section, if you look at question 5B of June 2021, was a sample judicial review you are supposed to draft, and I drafted one. Of course, the marks given there for the question was 5B June 20 was 5 marks, which was not commensurate to the question. That is CRE for you. You say, in the matter of Constitution of Kenya 2010, Article 23, 3F, in the matter of application for orders of certiorari, that is the heading. In the matter of Section 8 and 9, then chamber summons, Another order you can place is that an order prohibit directed to the respondent from continuing with the criminal proceeding against the ex parte applicant. Then in fact, the heading there I'm going to amend. The applicant there are supposed to be the Republic. Then the ex parte applicant was supposed to be that. Then the another order is this leave so granted that does operate for a stay of criminal proceeding as against the applicant. Then you state the case in the lower court. Then you say the cost of the application be provided for. Are we together to that point?
Yes, we are together, Mwalimu.
So those in your question you add because you see when you say an order for Central to remove into this honorable court and quash the charge sheet in the chief magistrate court, the court will not quash the orders. It will not quash the charges at this level. This is just a leave for you to be granted now to bring the proceedings. So you must add another order for the proceeding to be stayed in the lower court. So the judge, when he's giving the order, he will give one of the orders he will give is for leave granted for you to bring now the notice of motion, then stay of proceeding. So another very, very important is that you add in your answer, any answer you are told to do JR, both in criminal or civil proceedings, which applications is based on the ground set up in the statement and annex here to on the ground as at the hearing, dated at Nairobi, days of 2023. So, statement. Statement, name and description of the applicant. The name of the applicant is Michael Kamersa, residing within Nairobi. He lives out. The applicant seeks an order of Central to remove vulnerable to cause the charges on the Chief Magistrate's Court, Nairobi. The ground upon the relief is sought. The charges sheet was materially developed extract the particulars of the sufficient detail needed to allow the applicant to ensure it or defend his cause. The prosecutors had refused to furnish the applicant with the requisite documentation information needed for applicant to prepare for his defense. The applicant was forced to take plea despite the charge sheet lacking sufficient details required for details required to ensure
Mwalimu, I had a question.
yes.
Why do we need to draft
Yes.
another affidavit? What is the purpose of this statement? Because I felt, okay, before you explained that what is actually necessary is affidavit instead of the notice of motion, I felt like the statement lays out our grounds very sufficiently and it supports our grounds. So I did not understand why I needed to do, why the affidavit would be so necessary over the notice of motion. Although now I've understood that in your chamber sermons, as long as you've prayed for leave and you've listed out your other orders, the court can give an order that you're granted leave and can give stay
Yes.
of the case continuing in the courts. But
yes.
like, why is an affidavit needed considering we have a whole statement?
It is in the, it is how the chamber summons is drafted. If you look at all the drafted chamber summons, you see, and order even 53, it talks about the leave documents are 3: statutory, JR through the chamber summon, the statutory statement, a verifying affidavit. Then after you are given leave, you draft now the notice of motion and supporting affidavit. That's how it should be. And that's why the question is 20 marks. You can't do the statutory statement and then you leave the verifying affidavit. Are we together? They go together.
Yes, we're together.
Yes, yeah, they got those 3 documents must be together. They go together. And that's why in an exam scenario, it is saved more if you are not directed. It's save more to do the petition, because petition, you do petition and start and petition and supporting affidavit. But this you must do the 3 documents together, which is a lot of work. So if you are not directed in a question in an the petition. So on your statutory statement, the relief sought, of course, we have told you you add the second relief, then the grounds in which the relief is sought, which we read there before, which is okay. Then you do the verifying affidavit.
Yes.
You do the verifying affidavit. Notice of motion is not necessary for question of 20 marks. It's a lot of work. And when you do notice of motion, of course, the notice of motion does not stand alone. It is also must have supporting affidavit. So that means you are supposed to draft five documents and a question of 20 marks, which is not practical. So you do those 3: JR, statutory statement, and verifying affidavit. So we jump, then we go to the petition which you drafted. Of Kenya, in the High Court of Kenya, Constitutional and Human Rights Division. So, you can hear me, eh?
Loud and clear, Moy.
So, Zoom is okay. It's misbehaving, but next time I'll be sending you the link to both to you and Ruth on private, because even the others have never joined. So that okay, let's continue. So Republic of Kenya in the High Court of Kenya and Nairobi Constitutional Human Division Constitutional Petition number of 2023 in the matter of contravention of and threatened contravention of fundamental rights and freedom. You add that, Michael, petitioner, director of public prosecution, and chief magistrate, Nairobi. Petition, the humble petition of Michael Kamau Of course, you use 28 marks, 28 minutes. Because you did not do the supporting affidavit. If you could have done supporting affidavit, I think you could have done the NINI on time. So, the humble petition of Michael, whose address for the service for the purpose of petition is Company Limited for Jubilee House and description of parties. The petitioner is a male adult of sound mind, residing and working for Gain, Nairobi County within the Republic of Kenya. The first respondent is the holder of constitutional office established under Article 157 of the Constitution as mandated instituting and undertaking criminal procedure against any person before any court, respect or any offense alleged. The second respondent is the holder of judicial officer established under Article 169 of the Constitution. You don't charge you don't describe chief magistrate in Nairobi. You don't sue the judicial officer in his personal capacity. You sue the office. So you say the second respondent is a magistrate court in Nairobi, established under Article 169, which is supposed to hear, which is responsible to hear criminal cases under Criminal Procedure Code. You don't sue the judicial officer. Are we together?
Yes, Mwalimu.
You sue the office, not the judicial of your background. The High Court has jurisdiction to hear and determine the application of redress, denial, violation, infringement of data, infringement of fundamental rights in terms of Article 23. The petition was charged in September 20 in the Magistrate Court after his employer accused him of colluding with the insured clients to write favorable reports for occupation. The charge does not discuss particulars of the offense, and despite several requests by the petitioner has refused to supply him with the particulars, and he was supposed to take particulars of violation. So you go now to the particulars. Article 250B. Even before you go to Article 250B, you start with Article 47. You go sequentially by saying the right to fair administrative action by Britam and by the police also. In fact, in your petition here, you can also add the third respondent as Britam Insurance. Are we together?
Yes, Mwalimu.
Then you go to Article 49 of the right of arrested person, particulars of the violation. Then Article 49, you say, the right to be informed promptly in the language that the person, the reason for arrest. No, he was not given the reason for arrest. And then you go to Article 52B, the one you have said, to inform the charge with sufficient details. Okay. Then 2(1) provides that the accused person has the right to remain silent. Then you also needed to quote 2C, which says that to have adequate time and facilities to prepare for defense. By him denying the particulars of the document, they were infringing on 2C. Then J, to be informed in advance the evidence the prosecution intends to rely on and to have reasonable access to that evidence. Then you could, of course, 2I. So those were some of the violations, which calls for you to have understood, for you to understand the Constitution very well. Then you go to your petitioner, therefore humble praise for the following orders. An order of Central to remove into the court for quashing the charge sheet in the Chief Magistrate Court. An order for damages for an order of Centrori to remove into the court and quashing the charge sheet in the Chief Magistrate Court. An order for damages to the petitioner for a violation suffered because of the suit. Then dated, then you do the supporting affidavit. And you are okay. So supporting affidavit, Nini petition is better than JR application. Are we together?
Yes, we are, Mwalimu.
So we go to the next question, which is, and of course you can look at, question 3 October 2022 is a petition, and then question 5B June 2021 is a judicial review. So we go to the next.
Mwalimu, if you don't,
Yes.
When you have time, just list them, because the way we are moving quickly, I'm unable to note them down. So if you could just list them, I can go through. Even if I want to draft anything, I could at least attempt the petition again.
Yes. We are going to Nini. We are going to, I'm saying, you know, petition, we are going to find it somewhere else, in our study. Yes. So this is not the end, even JR. I'm saying, question 3, October 2022 is a petition, criminal. Then question 5B, June 2021, is a JR. But JR, I'm going to change there. The applicant is supposed to be the Republic. Then there below, after you read the respondent, you are supposed now to say the expert, the applicant. That's how it should be for JR. The applicant is a Republic, then the respondent, then you say there below, expert, the applicant. It's not the way I've done right now. Then, but for the petitioner, is the petitioner and the respondent. So, it's cause for this is a common question. I can tell you the exam that you are going to do, criminal or civil litigation, you can take this to the bank. That one of the questions, either in civil litigation or criminal, is going to test you this, either JR or petition, either a theory question or a drafting question. So it is very, very, very important for someone to know how to draft these pleadings. Are we together?
Yes, we are, Mwalimu.
So we go to the next question, which is motion to quash charges. Then we go to bail and board. Bail and board, There was a question on anticipatory bail. Anticipatory bail. Not this one. Not this one. This is the last one. So, let me open the part 2. This is part 2. Part 3. So it was in part 1. Anticipatory bail has been tested in the past. In 2 questions in the past. I think the last time it was tested was in 2018. So that means now we are in 2023. It means it's a very highly likely question. And now I want to open your answer. Of course, for you to draft a very good application for anticipatory bail, you must know the principles that the court that you must argue for you to succeed in an application for anticipatory bail. Question 1, November 2017. Let me open the question. And of course, July 2014, we are done with that. We are done with subfile. We are done with July 2013. We are done with the charge sheet. We are done with sample charge sheet. So question 1, November 2017. You used 45 minutes. So the question is projecting on your screen. And you see, draft the necessary documents for filing in court. 20 marks. So if it's a question of 20 marks, that tells you you're going to use around 50 minutes. And the drafting must be very substantive with a lot of details for you to earn the 20 marks. And I can read now question 1, 2017. Mr. Rana, a political activist who hails from Ziwani County, where he was declared interest in seating the current governor, Major Retired Ebed, who he accuses of mismanagement of the affairs of the county. Major Retired, who was previously served as Inspector General of Police, is not to take kindly who opposed him and said he still holds a lot of influence within the police rank. In fact, he influenced the posting of Ziwani County Police Chief, Mr. Musa, who is his son-in-law. Mr. Musa has several ordered the arrest of Mr. Ranga on trap-up allegation ranging from holding illegal gathering to assaulting law officers, but he has never been arraigned in court for any offenses of these charges. Mr. Ranga believes that his arrests are meant to intimidate him to drop his ambitions. On 20th February 2017, when Mr. Ranaga was away in Nairobi with his family, violent protests erupted in Ziwani County outside the governor office by the county employees who claimed several months of unpaid salary. While still in Nairobi, Mr. Raga is informed that Ziwani County Police, led by Mr. Musa, have launched a manhunt of him, accusing of being behind the protest. Several of his supporters were also arrested on the day of the protest and have been produced in court for more than 2 days. Mr. Raga is apprehensive that the threatened arrest is politically motivated and is likely to infringe on his rights. He now instructs you to take up the matter in order to protect his rights. Draft the necessary documents for filing. So, application for anticipatory bail. 350 to 435, you used 45 minutes, which was okay. Anticipatory bail, usually done through a miscellaneous criminal application. And then miscellaneous criminal application notice of motion. Of course, certificate of urgency, very good, because it is 20 marks and there is urgency. So, Republic of Kenya High Court at Nairobi, miscellaneous application number. I told you to be drafting according to the time the exam was done, not the day we are doing it. Eh? Are you together?
Yes, ma'am.
Yeah, you be putting 2017 here. In the matter of Chapter 4, Article 20, 22, 23, 27, 29, and 49 of the Constitution, activist rages there is no someone called an activist as an official name. Eh? You give him a name called Reja Kamau or something. Eh?
Yes, Mwalimu.
There is no official name called an activist. Applicant versus Director of Public Prosecution and the Inspector General of Police. Certificate of Virgin. Nyambura Jini. Of course, in an exam, you put your name. Miriam Karaoke. Or put your box. And, if you are told you are the advocate. do hereby certify the application herewith is urgent for the applicant is oppressive. That's right to rebuttal may at any time be infringed as he remains in sorrow until proven guilty by a competent court. I therefore certify that the matter should be placed before the duties of an expedient hearing and disposal, include the grant of necessary ex parte orders in the instance dated, then come to the notice of motion and Article 22, 23, 27, 29, 49 is the most article on right to bail. And you don't, I told you in a criminal proceedings, you don't put, you meant criminal procedure code, not civil, eh?
Oh, yeah, that was a mistake. I don't even know how I did that. Yeah, that was a mistake on my part.
Yeah, it is criminal procedure code, section 39, 123, and 124. Be sure of the section you are quoting. Take notice that this honorable will move on the door on 2017 at 9 in the forenoon as soon as after the hearing and the sparkling applicant by counsel of the aquifer orders that the honorable certify the matter adjourned and the same be had ex parte in the first instance. That the honorable court be pleased to appoint or grant applicant anticipatory bail or bail pending arrest for any bailable offenses considered to rising from alleged complaint of Governor Major retired Albert, Governor of Ziwani County, and Mr. Police Chief of Ziwani, that this honorable court be pleased to issue other orders that be just and proper for protection of the applicant fundamental right under Chapter 4. So, when you are dealing with anticipatory bail, a very, very important order that you should also include that that the police be preventing from arresting the applicant, because the court will give him the bail and they will be prevented from arresting him. Are we together?
Yes, Mwalimu.
So that is a very, very important ground you must include here when you are drafting the order, the application for anticipatory bail. Which application is grounded on the applicant is either to be arrested by officer of Ziwani County, a complainant, and orders from governor and police chief by an illegal charge causing violent protest in Ziwani County, and any further based on the supporting affidavit of the activist Rana and such a ground as the hearing. Supporting affidavit. I, activist Raja, out of mind of PO Box Ziwani, Republic of Kenya, do you have all the sworn that the applicant hearing that's competent in matter hearing has competent to swear this affidavit that they are political activists in the Ziwani County with a vision to fight for governor, to assist the carpet governor. That I'm previously accused governor of misappropriation of fund and he ordered my arrest severally, Trump charges, but I have never been arraigned in court. That the arrest meant to intimidate me to drop my ambition. That the violent process that erupted in one county by a county of place over a peace arrest on 2019. That violent protests have erupted in one county by county employees of unpaid salaries on 20th February 2017. That the police, Mr. Musui, Governor Belt's son-in-law, have launched a manhunt for me and ensuring me to bring behind the protest. That some of my supporters have been arrested and have not been produced in court for more than 2 days. That I'm apprehensive that I'll be arrested with politically motivated and is likely to infringe my rights. That I make an application in support of my application for anticipatory bail and abide by the terms of the said by this court, that I swear the affidavit believing that contexts are true to the best of my knowledge, sworn by the said before me Commissioner of Earth to be served Director of Public Prosecution, Inspector General of Police. So, generally, you did this well, except for adding that application, adding that prayer of the respondent or the police preventing being prevented from arresting the person. So we go quickly to our last question, which was testing on so our last question for the day is you can hear me, Marian?
Very well, Mwalimu.
Yes, I'm going to investigate why it's bringing problems, but we continue nevertheless in the next 10 minutes before we wind up. Jokayo was charged in criminal case number 800 of 2019 before the Chief Magistrate, Mombasa Law Courts. He was charged with 2 counts of dealing with the right draft of an endangered species without a permit contrary to Section 92 to avoid Wildlife Conservation Management Act 2013, and in the possession of a specific wildlife trophy without permit or lawful exemption, contrary to Section 92(4) of the Act. He was convicted by the Summary Court to life in prison and immediately filed an appeal. His brother, Peter Kayo, has now contacted you to secure the freedom of his brother pending appeal. Draft the appropriate application. So this question required you to draft the bail pending appeal. And this, of course, is a mock question because it has not been tested anywhere between, other theory questions have been tested from 2008. So these are very likely question that can come in November. You can be given 10 marks, 15 marks, 20 marks. So I want to now project your answer.
Mwalimu, I had a request.
Yes.
When you find time,
Yes.
can we go through the concept? Okay, I think it's more of an application, notice to show cause. I've been seeing it popping up and I really don't understand. Like I saw it there was a disciplinary hearing for an advocate, and he was being asked to show cause why he should not be struck off, or maybe like notice to show cause why some property should not be attached. So if you could just guide me on how that is done, I'd be very happy in a future class.
Okay. Notice to show cause.
Yes.
Drafting and also theory. I think I've written down. We are going to start with it next time.
Thank you, Mwalimu.
Yes. So this is the one that Nani did, but Ruth. But of course she's not here, and I'm looking at your Nini. I'm looking at your answer. Okay, you sent me this morning, so let me just open. Pending appeal. Save us. Open. Let's do this.
Yes, Mwalimu.
I think let's end there for today.
Okay.
We are going to end there for today. We are going to start from next time. We are going to start with the bail pending